As stated in the previous section, we are constitutionalists and require all public servants, including judges, to abide by their oath in the performance of their official duties, including those before the court. This protects the American citizen from government and court abuse. If enforced, the previous challenges are intended to stop any action before it gets to court. Those listed below are intended to be stated or asked by the defendant in court prior to the start of proceedings. They require yes or no responses. Remember, I don't need any of their mumbo jumbo and them trying to justify their thinking. All right? It's either a yes or a no. It's real simple. And you must hold the judge only to these answers. If you allow him to evade and avoid answering as such, then you yourself allow the judge to damage you, your lawful position, and the powers of and rights guaranteed in the Constitution to you. As you can see, either a yes or no answer serves your interest if you understand the implications. For the sake of convenience, we shall assume the position as defendant. Please remember that all public servants serve under limited delegated authority from the Constitution by and through the people for the best interest of the people. The American people must gain courage en masse and stand up to and challenge all forms of government, especially the courts, which are supposed to be the last bastion of justice. Since the Constitution cannot conflict with itself, the limited powers delegated to government by the Constitution can never supersede the powers of and rights guaranteed in the Constitution to the American people. Authority is an extremely important word and concept. Nothing lawful can be conducted by government and the courts without constitutional authority, and government has no authority to disparage your rights. Keep authority in mind as you review the following statements and questions. Challenge is not argument. Sovereigns make demands. Demands are either met or they are not met. Subjects make requests. Motions. Requests can be either granted or denied. Challenges in court before proceedings start. These statements and questions can be directed to the judge for himself, the prosecuting attorney, and state witnesses, such as police officers, etc., or police, and to each one individually. Not all of these need be asked, so ask those with which you are most comfortable. If both you and your opposition fully understand the very serious lawful position and constitutional implications of the statement and questions, usually only the first one is needed for constitutional justice to be served. Question number 1. You have taken an oath of office. Is that correct? Yes or no? I don't need a fucking biography of how you want to gallivant around it. Number 2. B. Pursuant to your oath, in your performance of your official duties, including those before this court, you are required to abide by that oath. Is that correct? Yes or no? I don't need an explanatory statement with it. I just need to know yes or no. Note, if the judge or the prosecuting attorney or other state witness say no, then obviously they must be disqualified and or removed from the bench, position, or impeached as witnesses, along with their testimonies, for obvious reasons. This answer is evidence that the one who answered no will not abide by his oath in the performance of his official duties. Therefore, by his own answer, his oath is meaningless to him. He is a traitor and a danger to the American people and must be removed from power. All those who have taken an oath are required to answer yes. This answer is consistent with the requirements under the oath, the bond which binds the oath, and requirements of the Constitution. A yes answer means that all actions taken by the public servant, past, present, and future, must be consistent with the constitutional requirements. Specific to the Bill of Rights, if the public servant's past actions failed this, and if those actions are used in an action or as evidence against the defendant, then those actions were not taken pursuant to his oath and were done in opposition to constitutional requirements. Therefore, the public servant purged his oath. invoked the self-executing Section 3 and 4 of the 14th Amendment, vacated his office, and forfeited all benefits of that former office, including salary and pension. All charges must be dismissed with prejudice. He must be disqualified from his position, and if a witness, he and his testimony must be impeached, and all his unconstitutional, unlawful actions and evidence against the defendant must be denied, and the charges dismissed. All present and future actions by the judge and court must be conducted pursuant to the Constitution, federal and state. In this situation, if you are fully aware of your rights and the full extent of the yes answer, you will prevail. However, if the judge were to then, after violate his answer by his actions, you must inform him of his answer and his constitutional requirement thereto, and his liability if he were to fail in his duty. Remember, they have nothing. They want everything, and they want you to give it to them. Language creates spooks that get into your heads and hypnotize us. Robert Anton Wilson, Introduction to the Tree of Lies by Christopher S. Hyatt, Ph.D. The next title is It's Hard to Fight an Enemy Who Has Outposts in Your Head, Sally Kempton. The most potent weapon in the hands of the oppressor is the mind of the oppressed. Steve Biko. What Nietzsche said, the state, what is that? Well then, now open your ears, for now I shall speak to you of the death of peoples. The state is the coldest of the cold monsters. Coldly it lies, too. And this lie creeps from its mouth. I, the state, am the people. Number 2. Does this court abide by all the powers of and rights guaranteed to American citizens in the federal and state constitution, including due process of law? Yes or no? Note, a no answer carries the same conditions as above. A yes answer is in compliance with constitutional requirements for American citizens and is consistent with the yes answer to number 1 above. Again, if you are fully aware of your rights and the conditions underlying the affirmative answer, you will prevail. Remember, bind the judge by his answer. Due process defined under Goldberg versus Kelly, 397 U.S. 254, 1970. Timely notice, confront adversarial witness, oral arguments, oral presentation and evidence, cross-examination of adverse party, right to assistance of counsel, disclosure of evidence, determination of outcome of a court of record, so you don't have to do it again, right of finding of facts and conclusion of law, right to have the reasoning as to why the judge did whatever was done, and right to impartial judge. Due process, an orderly proceeding wherein a person with notice, actual or constructive, and has an opportunity to be heard and to enforce and protect his rights before a court having the power to hear and determine the case. Kazaboski versus Kazaboski, 45 III 2D 405 259 NE 2D 282 and 290. Phrase means that no person shall be deprived of life, liberty, property, or of any rights granted him by statute, unless matter involved first shall have been adjudicated against him upon trial, conducted according to established rules regulating judicial proceedings, and it forbids condemnation without a hearing. Petiti versus Penn, LA APP 180 SO2D 66 and 69. The concept of due process of law, as it is embodied in the Fifth Amendment, demands that a law shall not be unreasonable, arbitrary, or capricious, and that the means selected shall have a reasonable and substantial relation to the object being sought. U.S. versus Smith, D.C., Iowa, 249 F. Superior Court, 515, 516. Fundamental requisites of due process of law is the opportunity to be heard, to be aware that a matter is pending, to make an informed choice whether to acquiesce or consent, and to assert before the appropriate decision-making body the reason for such choice. Trinity Episcopal Corp, EPISCOPAL Corp versus Romney, D.C., New York, 387, F Superior Court, 1044 and 1084. Aside from all else, due process means fundamental fairness and substantial justice. Vaughn versus State, 3 Tennessee, CRIM, appellate level 54, 456, SW2D 879, 883. I am entitled, number 3, I am entitled and guaranteed a fair and impartial trial presided over by a fair, unbiased, and impartial judge before and decided by a jury of my peers. Is that correct? Simply yes or no. Note, a no answer is consistent with conditions stated above. A yes answer confirms the condition of the statement, including 1, right to a fair and impartial trial, and 2, unbiased and impartial judges, and 3, a jury of my peers, and 4, which juries decide guilt or innocence, not guilty or not guilty. A bad faith prosecution violation constitutional rights, Cornett versus Logies, 871 F Superior Court, 918, 921 through 922, ED, Texas, 1994. There are 2 types of ignorance. The first type of ignorance is that brought about by nature, where an individual doesn't have the mental capacity to seek and or understand it. The second type of ignorance is chosen ignorance. This is the byword of fundamentalist Christianity. Through half-truths. Half-truths are whole lies, purposeful semantics, manipulation, and finged knowledge and wisdom. They trap you with gully lies. As Paul said to the Corinthians, the truth is out there. You need to find it for yourself. No one has it for you. Number 4, I am presumed innocent of all aspects of the alleged charges, presumptions, and assumptions in, by, and of this court, unless proven guilty by a jury of my peers, beyond a reasonable doubt, based solely on verified evidence and proof. Is that correct? Yes or no? Note, either answer is consistent with conditions as stated above. However, in this statement, with a yes answer, you are confirming several vital positions. 1, presumed innocent of all aspects of the alleged charges. 2, presumed innocent of all presumptions and assumptions of this court. 3, unless proven guilty by a jury of my peers. And 4, proven guilty beyond a reasonable doubt. 5, based solely on verified evidence and proof. And further, Texas Penal Code, Section 2.01, Texas Code of Criminal Procedure, Articles 38.03, and the United Nations Universal Declaration of Human Rights, Article 11, clearly states that all persons, people, are presumed to be innocent. I go with that. I will not make any admissions or confessions to the contrary at this time. 5. A. Proof consists of verified and demonstrated competent evidence and not opinion, especially opinion unsupported by fact, law, and evidence. Is that correct? Yes or no? Note, in this statement, by the judge's answer, you are confirming the nature and status of proof. It is highly unlikely that any judge will, on the public record, answer no to this statement, since his answer will defy the very loudly proclaimed concept of American justice, will defy due process of law, deny constitutional rights, and allow opinion, unsupported or otherwise, to be used as proof. A. Yes. Answer will be consistent with the judge's oath, constitutional requirements, and his oath, and his other yes answer. He will confirm the statement and the fact that opinion, verified or otherwise, is not proof. This is a major position, a major lawful gain and benefit. Many testimonies by witnesses are simply opinions, usually unsupported and unverified. The defendant can now be assured that only verified and documented proof, and not opinion from anyone, can be used against him. B, beyond a reasonable doubt, consists solely of decisions and verdicts from a jury of my peers based entirely on proof that absolutely and conclusively confirms guilt, without any reservation or questions whatsoever from the jury. Is that correct? Yes or no? A lot of people like to go raise hell on a Friday night, and I'd rather see my American people and furthermore people of the world ascend to the mind. So this is what I do for fun on a Friday night. About 10 years ago, my lifestyle was a little different. Note, A, no answer is consistent with conditions above stated. A yes answer confirms all the conditions of the statement, due process of law, constitutional requirements, the judge's oath, and assures that a jury of your peers will make its verdict based solely on proof, not opinion. That absolutely confirms guilt without any question whatsoever. Number 6, opinion. From any witness or prosecuting attorney unsupported and unverified by fact, law, and proven evidence is simply opinion. And opinion, as previously established, is not proof. Is that correct? Yes or no? Okay, Trinsley versus Pagliaro. Anybody testifying without first-hand knowledge of the pains and penalties of perjury and independently bonding their statements of fact is a nullity. Get rid of them. Throw them out your court. Note, a no answer is consistent with conditions stated above. A yes answer, again, confirms the status of proof as different from opinion. Thus, any plaintiff or opponent, prosecutor or witness must have verified proof as described and not opinion to support his statements. This is of vital importance to American citizens. Therefore, proof by the prosecutor and testimony of the witness is only opinion unless supported as above stated, and if not, it is meaningless, frivolous, null and void, and not accepted by the court as proof of anything, including guilt. A judgment must be proven only by evidence entered on the record through a competent witness. See American Red Cross versus Community Blood Center of the Ozarks, 257 F3D 859, 8th Circuit Court, 725 of 2001. The statement of counsel in brief or in argument are not true facts before the court and are therefore insufficient for the court's summary conclusion. Trinsley versus Pagliaro, DCPA 1964 229 F Superior Court 647. 7A. Since I am guaranteed a fair and impartial trial, how is that possible when you, the presiding judge, the prosecuting attorney, and all witnesses against me work for and are paid by the state, which, by the way, the states, all their seals are registered in Canada after like 1971 or 1975, something along the lines. All the state seals are registered up in Canada. So they're working for a foreign principal with a foreign seal, and that hence why in 1938 and 1939 the Foreign Registration Act must be abided by. All right, they're all working for a foreign principal. They have to tell the Attorney General what they're doing on our damn land, and we need to start holding these people accountable. All right? Part of the problem, in fact, the majority of the problem is us. As soon as we realize that, we can fix it. Can't fix it if we're always going to be pointing fingers at everybody else going, well, it's his responsibility. It's his responsibility. It's his fault. Now, look in the fucking mirror, look at yourself and go, I'm not going to allow my kids to be fucking lorded over by tyrannical assholes that are lying, looting, pandering, stealing, thieving piles of shit that aren't compliant with the law. All right? Statutes, code, city ordinance, provisions, rules, regulations, all apply to them. The legislator passes and enacts statutes, codes, and provisions that apply to government and government fucking employees. And it's our responsibility to make an observation, create a record, and report these assholes and get rid of them. Can't be letting them unjustly enrich themselves on our watch. No. It's time. It's time to wake the fuck up and put our boot up their ass, and it doesn't require any violence. That is the most beautiful thing about it. It doesn't require an ounce of physical violence. And that's what's neat about this. All right, and things are changing. I'm starting to see police officers around the United States being prosecuted at a phenomenal rate. Okay, I'm starting to see other lawyers that are coming against other lawyers about the Foreign Registration Act. So for those of you out there that say, "Oh, that's been abolished, it doesn't work," blah 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 blah, I got news for you. The House Senate report, not more than 2 years ago, they were all on there talking about how nobody's compliant with the Foreign Registration Act of 1938. There's like 640 people on there when you go into the Foreign Registration Act and look into the database. Like 641 people. And almost none of them are lawyers. All of them should be lawyers. And there's hundreds of thousands of those rat bastard weasels out there. And they should all be compliant with it. And they're not. So put their balls in the damn fucking campfire and let's smoke some testicles, all right? It's time to fucking get their old crotch hairs on fire, you know? Put a fire under their ass. Get rid of them. Make them do what they're supposed to do. Make them pay the fucking taxes on the carryover basis under Title 26, 2603, 2203, 2002, 2001, because anybody that's in constructive possession of decedent or ceding estate property is cheating the United States, which is cheating the United States Treasury, which is directly affecting you and cheating you. So don't you want to help yourself out? All you got to do is promptly report these assholes because they're responsible for the transfer tax on a carryover basis. Let me get back to what I'm on here tonight for, and that is to help you guys out in court. The prosecuting attorney and all the witnesses against me work for and are paid by the state. That is the plaintiff in this case and my opponent. Okay, in this situation, it is impossible for me to have a fair trial. Is that correct? Yes or no? Real simple. B, further, any data used against me is obtained from sources who are also paid by the state. The same plaintiff against me. At minimum, conflict of interest takes place. Yes or no? Note, a no answer is consistent with above conditions. If the judge were to answer no, he is essentially saying on the public record that it is possible for a defendant to have that it is possible for a defendant to have a fair trial, even though he, the judge, the prosecutor, and the state witness all work for and are paid by your opponent, and that all the so-called evidence against the defendant was obtained from sources paid by the state against the opponent. Even the most avowed critic can see through this fraud. A yes answer confirms the condition of the statement and conclusively demonstrates that a presiding judge recognizes on the public record that the reference court conditions are not fair, not partial, and as such, unconstitutional. This is a major constitutional and lawful victory for the people with far-reaching implications. A fundamentally fair trial is a basic requirement of due process. Esther versus State of Texas, 85 SCT 1628. This case was executed in 1965. And pursuant to Ward versus Village of Monroeville, 409 U.S. 57, 61 through 62, 93 SCT 80, 83, 34 LED 2D 267 in 1972, and Toomey versus Ohio, 273 U.S. 510, 520, 447 SCT, 437, 440, 71 LED 749, 1927. It is a fundamental right of a party to have a neutral and detached judge preside over the judicial proceedings. But here's the problem. Here's the problem, Johnny. Little Johnny, you listening? It's either judicial or it's an administrative finding. Which is it? I'm just kind of curious. I mean, if you're going to enter a plea on my behalf, is that judicial or is it administrative? Because we accept the plea of not guilty, and we find that you've made a great decision. You're great. All right. Since I am presumed innocent of the charges and all aspects, presumptions, and assumptions of those charges and this court, I have challenged the jurisdiction of this court, which is an aspect of the charges and a presumption of this court. this court has failed to prove jurisdiction on the public record. Therefore, since I am presumed innocent of all aspects of the charges and presumptions of the court, I am presumed innocent of jurisdiction. And since this court has not proven jurisdiction on the record, this case must be dismissed pursuant to the foregoing and to numerous federal and Supreme Court rulings. This case must be dismissed with prejudice, and I hereby move for dismissal of all charges and this case with prejudice. Yes or no? By prior yes answers, it has been established that the defendant is presumed innocent of all assumptions and presumptions of the court. Jurisdiction is both an assumption and a presumption of the court, of which the defendant is presumed innocent. The defendant challenged the jurisdiction of the court, which the court failed to prove on the record. Therefore, since the defendant is presumed innocent of jurisdiction, has challenged jurisdiction, which the court has failed to prove on the public record, the court lacks jurisdiction, and since jurisdiction does not exist, the charges must be dismissed with prejudice, and pursuant to Hagens versus Levine, 415 U.S. 528 at 533, 1974. Once jurisdiction is challenged, it must be proven, ladies and gentlemen. Must be proven. You can't just say, I have jurisdiction, now sit down and shut up. It does not work that way. Does not work that way. If the judge were to deny this lawful position and insist that his court has jurisdiction without his having proven it on the public record, the following could be stated. Since the judge has stated that this court conforms to all constitutional requirements, this court conforms to the Bill of Rights, Article 3 of the Federal Constitution, and to due process of law. Jurisdiction is directly related to the foregoing, is an aspect of the charge or charges, and a presumption of this court, of which the defendant is presumed innocent. Yet, this court has failed to prove jurisdiction on the record. Thus, this court defies constitutional requirements, due process of law, federal and Supreme Court rulings, and therefore forfeits any perceived jurisdiction, has no constitutional authority to hear this case, and this case must be dismissed with prejudice, or the presiding judge, pursuant to his oath, perjures that oath, commits insurrection and sedition against the Constitution on the public record, and treason against the American people. Whew, that's a mouthful. Number 9. The jury swears an oath to the Constitution. Is that correct? In its deliberation and in its verdict, the jury is required to abide by its oath. Is that correct? Yes or no? Since the jury swears an oath and is required to abide by that oath, it is obvious that a yes answer is required. The constitutional and lawful position here is that the jury must abide by its oath in making its verdict. If it fails to do so, then the jury perjures its oath. Its actions and verdicts are unconstitutional, and the jury verdict null and void, without force or effect whatsoever. Just as a public servant is required to abide by his oath in the performance of his official duties, so is the jury. However, we the people must know and demand our rights, or we have none. If the judge were to answer no, which is highly unlikely, then as a defendant, I would move for immediate dismissal of all charges with prejudice, because any judge or court that permits an unconstitutional jury to perjure its oath and reach an unconstitutional verdict pursuant to its oath operates as an open fraud upon the people, denies and defies the Constitution and the powers of and rights guaranteed therein to the American people, denies due process of law, and has no jurisdiction over any American citizen whatsoever. B. If the jury, pursuant to its oath, makes its verdict in perjury of its oath, or in opposition or contradiction to the Constitution and the rights guaranteed therein to American citizens, or based in false information and fraud, that verdict is plainly unconstitutional, thus null and void, frivolous, and without force and effect whatsoever. Is that correct? Yes or no? answer given in previous note, further pursuant to oaths taken, any jury verdict based, either in whole or in part, in fraud, deception, manipulation, lies, or false information is null and void. If the judge were to say that this is not correct, then I, as a defendant, would inform him, pursuant to his oath, and pursuant to his proceeding, yes, answer, why his response is not only incorrect, but unconstitutional and unlawful. Further, I would inform him that he has no constitutional authority to deny, on the public record, the very Constitution to which he and the jury swore an oath. Bound by bond, it is obvious that the judge is not a higher authority than the Constitution. If the judge were to insist that the jury verdict, even when based in fraud, etc., as above described, is valid, I would remind him of his first yes answer to the statement number 1, in which he is required to conduct his professional duties pursuant to his oath, as is the jury also required. I would then remind the judge of his other yes answer, in which he confirmed, including but not limited to, the constitutional duties of the court. His response is made in contradiction to his oath, as is the jury's verdict. Thus, both are unlawful, unconstitutional, without force and effect whatsoever, and not binding in a constitutionally compliant court, which the judge stated on the public record is the status of this court. At this point, I would move for immediate dismissal of all charges and this case with prejudice for including but not limited to lack of jurisdiction, lack of constitutional authority, defiance of the federal and state constitutions, denial of due process, perjury of oath, insurrection and sedition against the Constitution, and treason against the American people. In the instant case, the defendant. It's also considered mixed war, ladies and gentlemen. Go look up what mixed war is. If the judge were to retain firm, then, as a defendant, I would inform him that I am entitled to a fair and impartial trial by a jury of my peers, as he previously agreed, and as is constitutionally guaranteed. Yet this jury is not a jury of my peers for many reasons, including but not limited to, number 1, jury members are not part of my ethnicity. Number 2, they do not work in the same profession I do. Number 3, they do not come from the same background and education that I do. Number 4, they are not constitutionalists and supporters of the supreme law of the land as I am. Number 5, they are traitors to the Constitution and to the American people, which I am not. I would then again move for dismissal of all charges and the case with prejudice based upon previously stated grounds, and further include the fact that the judge would permit an unconstitutional verdict by a lawless, unconstitutional jury not of my peers. The Constitution guaranteed me a jury of my peers, yet this judge denies this constitutionally guaranteed right to me. Pursuant to his oath, he has no constitutional authority to overrule the very same Constitution to which he swore an oath, and further, is not a higher authority than the Constitution. If the judge were to remain firm, I would again inform him that by his own actions and responses, he committed insurrection, sedition, and treason against the American people, is a traitor to this nation and its people, and must be removed from the bench for his treason. I will immediately file criminal and civil charges against him, personally and in his professional capacity, and take action against him in an Article 3 federal court, which I will demand by motion. Here's the other thing that's not being mentioned in here. This is something Mr. Anonymous pointed out to me the other day. He said, the sheriff can do this thing called a sheriff's inquiry. But unfortunately, the local sheriffs always have the fox squeaking in their ear. Oh, don't listen to that guy. Don't listen to that guy. He doesn't know what he's talking about. He's foreign. He's cuckoo. He's one of them sovereign citizens, But here's the facts. Facts, Jack. Your local sheriff, if you can get him to get off his ass and read a book once in a while, has the ability to do what is called a sheriff's inquiry. Oh, that's right. Oh, that's right. He can be a badass if he wants to be, because a sheriff can literally conduct an investigation, compel a grand jury to convene, put before them his evidence, and allow 25 people to decide whether or not a crime is afoot or not. And then he could turn around and move it to the federal court and have him prosecuted. Now that's some badass shit right there. But you're going to have to get your damn sheriff to come out of hiding from behind lawyers and grow a set of balls and stand up and go, you know what, something ain't right in this country, and I'm fighting for you people because you believed in me. You believed in me, so I'm going to protect every last fucking one of you. All right? So we need them to start becoming astutely aware that they work under the executive branch, not the judicial branch, and their primary function is to watch, make an observation, create a record, and report it. But that's not what we're finding in these courts. In these courts, the sheriff enforces that you can't bring a cell phone in because the criminals, well, to be real honest, they don't like being recorded while they're engaged in their criminal activity. So, let's get back to this once again. I just wanted to just put that in your head because that more than likely will not be within this literature. It's called the sheriff's inquiry. If the judge were to remain firm, I would again inform him that by his own actions and responses, he committed insurrection, sedition, and treason against the American people as a traitor to this nation and its people, and must be removed from the bench for his treason. That's called citizen's arrest. Sheriff, tipstaff, you're now my tipstaff. Get over here and arrest this son of a bitch. Get him out of my sight. Take him out of this courtroom. Take that damn dress off that cross-dressing weasel and put his ass in a fucking cage. All right? I will immediately file criminal and civil charges against him personally and in his professional capacity and take action against him in an Article 3 federal court, which will demand by motion. Questions to ask the jury. Number 1, pursuant to your oath, is there anyone on this jury who will not abide by his or her oath in the performance of his or her official duties, including but not limited to jury deliberation and reaching jury verdict? All right. Number 2, are there any jury members who believe and will abide by the belief that the government is superior to the people and that government is sovereign in this nation and that the people are required to obey the government in all situations, no matter how unlawful and unconstitutional that government or its actions may be? Now, let me just put something in your head. I was a pretty ornery little shit, all right? There ain't no bullshitting anybody on that one. I barely listened to my folks, and they did the best they ever could to raise me to be an honorable man with integrity, to make sure that I did the best I could to represent my friends, my family, and my loved ones, right? If that be true, and I barely listened to them and they had my best intentions at heart, what makes you think I'm going to listen to a lying, looting, pandering piece of shit trying to lord over me? Are you off your damn rocker? Have you lost your testicles? Seriously? What makes you think I'm going to listen to any other grown-ass man that's never been a part of my life trying to lord over me and tell me what the fuck I'm going to do? It just doesn't work that way. Doesn't work that way. It never has. Never fucking will. I mean, the only people that were able to do that to me used to, have to put a lick on me once in a while because I wasn't listening. All right? But those people I respect, those people have authority over me. When my mother asked me to do something, I go and do it. Why? Well, because she brought me in here. She can take me out. Fair as that. I mean, it's about as simple as it gets. But even at a young age, I didn't listen to them. What makes you think that I'm going to be subservient to some jackass because he went to school and got a piece of fucking fancy paper and thinks he's somebody? All right? Fuck off. Fuck out of my country, you lying, looting, thieving bastards. All right. And the other thing is, if you start to inform a jury or educate a jury on all this, you're going to be stifled by a black robe cult member, all right? Because they don't want anybody catching on to their scheme. It's a fucking Ponzi scheme, people. All right. Number 3, are there any members on this jury who are lawyers, government officers, or work for any form of any government in any capacity or are employed by corporations or companies that work for government? Now, that's a hard-hitting question. We're talking about federal employees are not allowed to sit on a jury. So if they have a social security number, they are disqualified. They get government benefits, period. There's food for thought. Bet nobody was thinking about that one. Number 4, are there any paid informants, paid or otherwise, spies or agents, provocateurs on this jury for anyone, anybody, or anything? I want to just know, we're basically doing a deposition here. We just want to know on and for the official record, and none of you guys on the take. Number 5, you have been asked these questions and are expected to and will be held to your answers pursuant to your oaths. Does anyone wish to change his or her answer? Ooh. Extra. Do you discriminate? Do you discriminate in favor of judges and policemen? How many are prepared to vote right now to find me innocent? Then turn to the judge and say, your code of criminal procedure says I'm entitled to the presumption of innocence. Back to the jury. How many of you are ready to vote right now to find me innocent? I fucking love it. And pursuant to the Howlett versus Rose, 496 U.S. 356, 1990 case, federal law and Supreme Court cases apply to state court cases. And pursuant to U.S. versus Lee, 106 U.S. 196, 220, 1 SCT 240, 261, 27, LED 171, case had in 1882, no man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. Period. And it is the only supreme power in our system of government, and every man who, by accepting office, participates in its function is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes on the exercise of the authority which it gives. And pursuant to Cohen's versus Virginia, 19 U.S. 6 Wheat 264 404 5 LED 257, the case had in 1821, no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. That's called mixed war. It's a big, big no. And pursuant to the Preto Bail Bonds versus State, 994 SW2D 316, without the taking of the oath prescribed by Article 16, subsection 1C, oath of office, D, anti-bribery oath of the Constitution of this state, one cannot become either a de jure or a de facto judge, and his acts as such are void. And pursuant to State versus Jordan, 28 SW2D 921-922, a person elected or appointed to an office or other public position must qualify by taking an oath or making affirmation and by giving bond if so required by law. And pursuant to Texas Transportation Code subsection 543.008, violation by officer. If violation by an officer is misconduct in office, the officer is subject to removal from the officer's position. Further, the exercise of a constitutional right cannot be converted into a crime. See Miller versus U.S. 230 F2D 286 489. The claim and exercise of a constitutional right cannot be converted into a crime. Miranda versus Arizona 384 U.S. 436. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. And Shapiro versus Thompson, I always say it wrong, Thompson, 394 U.S. 618, the mere chilling of a constitutional right by a penalty on its exercise is unconstitutional. Is patently unconstitutional. Let me comprehend you. For your job position, are you employed under a collective bargaining agreement? Yes or no? In your job position, does your paycheck include federal funding or federal grants? Yes or no? Likewise, do you accept any funding from private enterprises to pay your paycheck? Yes or no? In addition, do you have an oath of office? Yes or no? to support the United States Constitution? Yes or no? And the Texas Constitution, Nebraska Constitution, whatever state of confusion you allegedly purport to live in, reside in, whatever, yes or no? I am sure your principal gave an oath and the principal agent rule under doctrine of respondent superior applies here. Let me comprehend you correctly. Are you intending to make a legal determination that you can hold me, a sui juris free man, liable for anything you think I am liable for without my agreement, for which I have not, will not, and do not agree for any liability, or to be compelled for any unrevealed contract, commercial agreement, or bankruptcy that I have not entered into knowingly, voluntarily, and intentionally from any administrative agencies of government, federal, state, and local like this agency here, or that you do not have to file these papers, or that you are ruling contrary to the higher courts. And you can cite your court cases. Because if you are intending to make any of those assumed legal determinations concerning me, you just may be placing yourself into committing an Article 3 impeachable felony offense. Is that really what you want to do? Yes or no? Is that really your intention? If so, please state so for the record. If so, please state so in front of my witnesses here. And any silence right here and now is your acquiescence of your intentions to do so. And if you continue here today without dismissing this malarkey, I will and do charge you with administrative and constructive treason. Isn't that right, John Doe and Mary Smith? John and Mary must each stand up and say yes. And I do charge you likewise with administrative and constructive treason. Bailiff, take them away, then shut up. If anyone makes a move to touch you, shout very loud. I am a non-combatant neutral in... Now, here's the problem with the neutral. As I start to evaluate street fights I've been in my lifetime, if you're within a certain proximity of me and there's a rumble going on, I'm going to tell you right now, I don't know that you're a neutral. And even though you got your hands up, I'm still going to remove you from the area. You might just get a light shove. I might just pick you up and throw your ass somewhere else. But I'm going to get you the hell away from me because I don't know if you're a friend or a foe. So a neutral in war don't work. You got to get the hell away from me. So you're a friend, not a neutral. You're a friend. You can't be a neutral. Neutral's a bad position. It's just as bad as being an enemy. So if you put that in your mind, put yourself in a scenario where you're in a street fight or something, there's 4 or 5 guys standing around you, you ain't going to let anybody stand that close. Not close enough to kick you in the freaking forehead while you're doing things elsewhere. You're going to remove everybody from your vicinity, and you're going to keep everybody at arm's length or further. Even if they appear to be a neutral, it doesn't mean they are a neutral. Maybe they changed their mind. Maybe they don't like you after all. You don't know. So keep everybody at arm's length. So just the same in here, there's some things I don't agree with. For example, I agree that I'm a non-combatant. I'm not a U.S. citizen. I'm not a combatant. I'm not an enemy belligerent rebel of the United States. I'm a friend, period. In High Tan Arai, on a journey, sui juris, free man status, and if you touch me, you will be in violation of the Geneva Convention and Field Manual 2710. Hearing nothing, this matter is dismissed and concluded. Leave the courtroom. All right? Pretty simple. Treason, simply put, a betrayal of trust, adherence to the enemy, and rendering him aid and comfort. See Camera versus U.S. New York 325 U.S. 165 SCT 918 932 89 LED 1441. See Title 18 USCA subsection 2381. Article 3, Section 3, U.S. Constitution, misprision of treason, the bare knowledge and concealment of an act of treason or treasonable plot by failing to disclose it to appropriate officials, that is without any assent or participation therein. For if the latter elements be present, the party becomes a principal. Title 18 USC UCSA. I think they just got this all backwards. Subsection 23A2. In other words, if I have knowledge of what I believe to be treason and I don't report it, I can be guilty of it myself. Powerful, powerful. So anyway, thanks for joining me. I appreciate it, and I appreciate all your support. Thanks for supporting me on selfgovernanceu.com. To everybody that supports me on that, as well as the classes, thanks for giving me the ability to bring this hard-hitting information to you guys. And enjoy your Friday night. I'll be on here a little bit later. I've got some more literature that was shared to me by Mr. Anonymous. He's like, hey, hit the books, do some videos, help some people out. So we always appreciate Mr. Anonymous, and thanks again for always sending your love, care, prayers, and donations. Talk to you soon.